इस केस की सुनवाई में आप देखेंगे, आपको संविधान नज़र आएगा, पूरा लोकतंत्र नज़र आएगा। वो कैसे कि विधायिका, न्यायपालिका और कार्यपालिका, तीन चीज़ें हमारे यहाँ महत्वपूर्ण हैं किसी एक लोकतंत्र को बनाने के लिए। और ये मामला है विधायिका का। लेजिस्लेटिव असेंबली में जो स्थायी समितियां होती हैं, परमानेंट कमेटी होती हैं, उसने एक रिकमेंडेशन दी और एक इंडस्ट्री को कि आपने बहुत ज़्यादा इसको पर्यावरण को नुकसान किया है, तो उसने अपनी रिकमेंडेशन में स्थायी समिति ने कहा कि इनके ऊपर 75,000 रुपये का फ़ाइन लगाया जाना चाहिए। अब हुआ ये कि वही सीधे सीधे आदेश इम्प्लीमेंट होने लगा, यानी उस पर्टिकुलर इंडस्ट्री के ऑनर तक पहुंच गया कि साहब आप 75,000 रुपये जमा करिए। इसमें वो पहुंच गए कोर्ट के, साहब ये रिकमेंडेशन दी है स्थायी समिति ने, बिल्कुल सही है, पर ये कोई विभाग जारी करेगा हमको, ये एक विधायिका नहीं कर सकती। तो विधायिका में हुए एक निर्णय को के लिए न्यायपालिका ने उस पर एक कानूनी निर्णय लिया और कहा कि कार्यपालिका का रोल है यहाँ। देखिए, समझने बूझने के लिए बहुत अच्छा फैसला है, बहुत अच्छी सुनवाई है, रादर मैं ये कहूँ। आइए देखते हैं।
रिकवरी ऑफ ₹75,000।
क्या वर्कमैन कंपनसेशन है?
नहीं, क्या वो विधानसभा कमेटी होती है।
हाँ।
विधानसभा कमेटी रिकमेंडेड फॉर इम्पोजिशन ऑफ फाइन ऑन द इंडस्ट्री।
अच्छा।
There was no order by the state government whether they accepted the recommendation or they straight away the RRC was issued by the collector in pursuance to the
पिताजी की बनाई हुई पिटीशन है, आप बहस कर रहे हो। वेरी गुड।
and there is no return on behalf of the state government. The Vidhan Sabha
कमेटी से रिकवरी कैसे हो जाएगी? There has to be some order.
Yes, there has to be some order.
जी बताइए मैडम, क्या कहना है आपका? Para 8 of the reply of respondent number 2. जी अरे लिखिएगा। श्री रजनीश गुप्ता, लर्नेड काउंसिल फॉर द पिटिशनर। श्रीमती स्वाति असीम जॉर्ज, लर्नेड पैनल लॉयर फॉर रिस्पोंडेंट नंबर 1, 3 and 4. None for respondent number 2. Next paragraph. Petitioner's grievance is that some decision was taken by the respondent
Some recommendation was.
The recommendation was made by the कमेटी का नाम पूरा बताइए। विधानसभा स्थायी समिति
permanent committee,
स्थायी समिति, which is constituted under Rule 213 of Rule of Procedure and Conduct of Business in Madhya Pradesh Legislative Assembly, and submits its report under Rule 215 Vidhan Sabha to make certain recovery of ₹75,000 on account of discharge of certain pollutants by the petitioner. Full stop. Next paragraph. Petitioner's case is that recommendations of the said permanent committee of the Vidhan Sabha were never translated into any order of the state government, which was required to be transmitted to the state government, and the state government was required to pass an appropriate order after affording an opportunity of hearing to the petitioner, and therefore mere directions of a permanent committee alone are not sufficient to sustain any recovery against the present petitioner. Next paragraph. The state has not filed any reply, though 22 years time has lapsed. Next, respondent number 2, that is additional secretary, Madhya Pradesh Vidhan Sabha Secretariat, has filed a reply under the duly supported by affidavit of one Shri B.D. Singh, son of late Shri Daulat Singh. Next paragraph. In this reply, it is mentioned in para 8 that after learning about the present petition, the committee has taken decision that all further action should be taken in furtherance of decision of this honorable court. Full stop. It is also mentioned in para 9 that in its 32nd report, the committee observed as under, within inverted commas, as the matter is pending before the Honorable High Court, comma, the committee closes the case, full stop, inverted commas, close, full stop. Next para. In para 10, it is mentioned that the action of the answering respondent cannot be questioned in view of the provisions contained in Constitution, provisions contained in Article 194 of the Constitution of India, and thereafter some citation of Kalpana Mehta versus Union of India is given without mentioning the name of the journal, comma, year, comma, volume or page, full stop. Thus, it is evident that, full stop, next paragraph. After going through the hearing learned counsel for the parties and going through the record, it is evident that the reply filed by the respondent number 2 is evasive. They have, on the one hand, admitted that they have closed the proceedings, but on the other hand, they have referred to Article 194 of the Constitution, which deals with powers, comma, privileges, etc. of the House of Legislatures and of the members and committees thereof. Full stop. Next paragraph. Issue involved here is not about the powers, comma, privileges, etc. of the House of Legislatures and of the members and committees thereof, but the issue is as to whether decisions of such committees can be directly translated into a penal action against a party who was not represented before the said committee, who was neither represented before the said committee nor was given any opportunity of hearing, and whether such decisions of the committee are required to be transmitted to the competent government for taking appropriate action. Full stop. On this aspect, return is silent. Full stop. Return of respondent number 2 is silent. Next para. This practice of mentioning the name of the judgment, name of the parties without giving complete citation is inappropriate practice. It is not only unethical but unprofessional too. Full stop. For which additional secretary and the counsel who filed the reply and who are definitely not covered under the provisions of Article 194 of the Constitution of India can be reprimanded. Full stop. Accordingly, questioning the demand, comma, having been made in violation of the principles of natural justice, comma, this petition is allowed with direction to the registry to communicate to the Honorable Speaker of the Madhya Pradesh Legislative Assembly to record a note in the service book of Shri B.D. Singh that he was trying to play hide and seek with the High Court by not giving complete citation of the judgment on which reliance was placed by them in para 10 of their return. There has to be some.
It would be too harsh.
Let it be. आपको क्या तकलीफ हो रही है?
नहीं हमको नहीं इनको
Let it be. Can they take court for a right?
नहीं ये तो है.
In above terms, petition is allowed and disposed of.